Now, the ATM says it has filed papers in the Constitutional Court on an urgent basis seeking clarity on the judgment of the Western Cape High Court this week that granted President Cyril Ramaphosa's bid to interdict Parliament's impeachment process. The interdict is applicable to public hearings or testimonies, and the ATM, a respondent in the matter, also the party that initiated the Section 89 process in Parliament. The party is seeking clarity on the implementation and effect of the court's order, adding that they regard this as a necessary effort to ensure certainty regarding the responsibilities of Parliament, the authority of the Constitutional Court, and the continuation of the Section 89 process. All right, let's take the story further now. We speak to the ATM's Parliamentary Leader, Vuyo Zungula. Vuyo, good evening to you, and thank you so much for your time. Perhaps we start with of course, we've just, spotted a little bit and then spoke about it a little bit in our intro to you on what exactly you're unhappy about, but please elaborate.
Evening, Sisbongi, to you and to everyone that has joined in. It's very important for the country to have court orders that are clear and that are not vague. The court order that was issued last week, it is the clearest indication of a vague court order. I'm saying this because people do not know. In fact, there's no certainty as to what exactly is being interdicted as per that order. Because the president asked in his court papers that the impeachment process must be interdicted. However, the court order says the public impeachment hearing is interdicted. We have a meeting on Wednesday. In that meeting, the ANC will argue that the entire process must be halted. Another person, like the chairperson of the committee, has already stated that according to his reading of that court order, it is only the public hearing aspect of things that are halted. Now, it raises questions as to why then would you have judges issuing court orders that are vague, that are open to interpretation, and would not lead to legal certainty. The other issue when it comes to the interdicting of the public hearing aspects, Section 59 of the Constitution guides Parliament as to how it conducts its business, that it must conduct its business in a manner that is open to the public so that the public is able to follow what their elected representatives are doing. Now, what does this court order on Friday actually do? It suggests that the public aspect of things are halted, meaning the impeachment committee can scrutinize or ask questions to Mr. Ramaphosa only if it is not in public. So that means that court order is in violation of Section 59 of the Constitution. So those are the main issues that we are raising, including the fact that when it comes to granting an interim court order, the Constitutional Court in the case of Godan ruled that if there's going to be any interim interdict that impacts a state functionary, the courts must actually pick into the main application and gauge on the prospects of success of that main application. And in effect, when the courts are picking into the grounds or the prospects of the success of the main application, they then will make a determination on the prospects of whether the review application will succeed or not. Mm-hmm. The judgment on Friday does nothing of that. It does not pick as according to what the Concord had previously ruled as to what must happen when there's an interim interdict that affects a state functionary.
So you do have, of course, some legal analysts, and I've spoken to a few, who've, read the judgment. I've also read it myself, and I know that there's been three. It's not unanimous, but the two, judgments agreeing to grant the president one, of course, a dissenting one. But you do have legal analysts who are saying that that is their understanding, that the chairperson of the Section 89 committee is in fact correct, that you can go on with all the other administrative work as long as you do not impede on, and also find yourselves in contempt of court with regards to public hearings. So you do have others who are saying that there is no confusion here.
Yeah. That is exactly why we need the Concord to actually assist with providing legal certainty. Because if on one side you have, because a court order in its effect should not have any form of ambiguity or vagueness. It must be clear so that it is easily enforceable. Like I stated, if you were to read the statement of the ANC issued on Friday, from their perspective and understanding, and one can trust that they'll go to that meeting on Wednesday to say that meeting must not sit. And you are going to have the chairperson of the committee saying the meeting must sit. So what does that actually mean? It means the court order that was issued on Friday fails because there is no because a court order that is vague, it is a court order that is unlawful, because how then do you proceed with a vague court order that depends on which side are you sitting on for it to be implemented? Because, yeah?
Pardon me for coming in there. You say that if it goes to the committee, then the chairperson will want one way and the ANC will want another. Isn't that something that you then settle as members of the committee and maybe take it to a vote? Do you think you won't have the numbers?
No, it's not about the numbers, because there is a court order. A court order, in its effect, it is because there is dispute in the sense that the president, who is the president of the ANC, has approached the court to interdict the impeachment proceeding. The impeachment proceeding, which is all of the processes regarding the impeachment committee, that is what he went to court asking
but
for.
I'm asking,
the court,
pardon me, I'm asking specifically about the issue of whether or not you continue, because you say that the ANC will want one way, right? And the chairperson will want another. So isn't that particular matter, because the ruling is there. We've seen it, we know, and the chairperson understands it's a certain way. So isn't that a matter, one can ask, that is that not a matter that the committee can settle when it comes to understanding, and also get the parliamentary legal team to also be in the meeting to settle that one? So you do have a person who can ask you to say, why not settle it in the committee?
No, not at all, because firstly, a court order must be clear. It must be very clear as to what must happen. It must not be open to interpretation. That's the first thing. And the issues or the unlawfulness of the court order will not be remedied by a vote in the committee as to whether we proceed with the meeting or we don't proceed with the meeting. The court order in itself should have been clear as to what exactly is being interdicted, and most importantly, interdict or grant an interdict based on the prayers. You don't go to court asking or praying for the process to be interdicted, and then the court grants you another prayer or grants you something else, and not explain what exactly is being actually granted. And the fact that you would then need another form of legal opinion in the form of legal advisors in Parliament to actually say what is their opinion, because as we're sitting now, you've spoken to a couple of legal advisors. Some of them will view it differently. Some of them will view it another way, which points us to what exactly is wrong with that order, because a court order, Sisbong, should be clear, should not be open to different interpretation, especially when it informs how it will be enforceable.
So what happens if it's not heard in the Constitutional Court expeditiously as you would want it to, which then could result in another delay? Because as a party, you were already unhappy with the fact that you may have to pause, ahead of Friday, before we heard the ruling. You are unhappy with the fact that you may have to pause because should the president not be happy with the outcome of the review application, either way, he might have to seek, relief from a superior court, and it may end up being on the doorstep of the Constitutional Court, and vice versa as well. Should the president be successful, there would have been parties that would have taken this matter forward, which then would result in more delays. So then now, what happens if you're not able to get into the court expeditiously and resulting in further delays?
Sisbongi, we filed our papers, and because we filed our papers, that then to appeal the judgment that was handed down on Friday, that then means the implementation or enforceability of Friday's court order is suspended because it is under appeal. You can't then proceed to enforce a court order that is appealed. So on Wednesday, in fact, there is no process of the impeachment that has been halted up until this appeal has been finally determined. The second issue, and I love the fact that you've touched on this issue, because it shows how this court order that was issued on Friday has got the potential of actually suspending the work of Parliament indefinitely when it comes to holding the president accountable via the impeachment, because the replying affidavit of the president for the matter that was heard for the interdict clearly stated that should he fail to convince the Western Cape High Court when it comes to reviewing the independent panel report, he is going to approach the higher courts. And when doing so, it means this particular court order this particular order that was handed down on Friday, he's going to seek an extension of that order, meaning it will be in effect up until there's finality in the form of the Constitutional Court. So we're not talking here about an interim interdict that will delay the work of Parliament for 1 or 2 weeks or 1 or 2 months, but we're possibly talking for years of possible delays. And that is in violation of Section 237 of the Constitution, where it mandates Parliament to carry out its processes and accountability functions without delay, because this particular court order, when read in terms of how it is worded, it means, Sisbongi, up until the Constitutional Court order, which took over a year and a half or almost 2 years to issue a judgment when the matter was heard on the constitutionality of the vote of December 2022. Only then that it could give the court, only then that the process could continue. So that is why from our side it becomes important that we deal with this. We'll deal with this now so that you don't have the work of Parliament, especially when it comes to impeachment, being halted by a court order. Again, that is a split court order, and a court order that violates or contradicts previous court orders when it comes to the public protector, because there's two different cases that dealt with the interdict. And those two interdict applications done by Advocate Mkhwebane were very clear to say you do not elevate the right or the perceived harm of the office bearer when it comes that they could have harm over the constitutional functionality and responsibility of Parliament of them to be held accountable. But this particular court order elevated the so-called reputational harm of the president over the need of South Africans to get answers as to what happened in Palapal.
So you do, of course, I mean, you've seen even with the review process, in fact, the ruling itself, right? It does speak about the fact that when you are then looking at the work of the Section 8-9 committee, for example, and the issue of harm and coming with the fact that to say if he were to go there, it doesn't mean that, let's say, for example, he's exonerated, then there wouldn't be a stain. And I'm paraphrasing, what it would have said here, that there wouldn't be a stain on the person of the president and the office. So when it comes to that, it seems that the president would have then made his case clear to the court, because yes, I know you speak about Advocate Busisiwe Mkhwebane, but when one could say that if maybe, for example, at the time the court was not convinced that she put forward a sufficient case, why then in this case, if the president was able to put forward, let's say, a sufficient case, would you then have a problem with the court saying that he's put forward a sufficient case and maybe the previous person you're mentioning didn't?
When you were to read the papers and also follow the argument when the matter was heard in Cape Town, you'll understand that, Sisbongi, the courts, even in the judgment, did not even give a particular reasoning as to what exactly this harm is the president worried about. Even the president, in his own papers, he speaks speculating that he may suffer harm, but it does not indicate what that harm can actually be, because we're in this process because of an independent panel report, and all that is in that report, and including that report, it is public knowledge. It has been in the public domain. Therefore, you can't then, I would never buy into an argument to say processing a report that has been in the public domain for years would amount to reputational harm to the president, because each and everything that will emanate from the impeachment committee, the basis of it is what has been covered in that report. And there's never been any harm on the side of the president over that report. And also, most importantly, he's always maintained that he's acted lawfully. Therefore, the only harm that we have now as a country is that South African citizens are harmed by not knowing or having the truth or having answers pertaining to Phala Phala. The president now has a platform in the form of the impeachment committee to dispel any issues that are false, that would, used by his political adversaries, to clear them out. That is the platform that is provided by the impeachment committee.
So quickly, before I let you go, I'm completely out of time. So are you saying that it doesn't give reason? So even from paragraph 91, for example, to around 94, you're not convinced that he's making a case there? Because, for example, you think, it says in part, the first judgment recognizes correctly, in my view, that the president's fears of injury to his standing and dignity are not frivolous, and saying that he, is correct, has a reasonable apprehension when it comes to harm. And then it continues to say that it is clear that if an interim interdict is not granted pending the review, the president faces the prospect of ignominy of public hearings in which he faces accusations of criminal conduct and unfitness for the office he occupies. The impeachment process is punitive and by its very nature entails a full frontal attack on the president's dignity. Deep humiliation is inherent in the nature of the proceedings. And then it continues. So are you saying that these particular reasons, in your view, were not sufficient?
Definitely not sufficient, because once you hold public office, you have got a responsibility to act in a manner that is consistent with that public office. And therefore, it cannot be that when you commit acts of misconduct and you violate the laws because of the power that you have in accordance to the office, public office of being president, when you are being asked or scrutinized as to what happened, what did you do, why did you violate this particular law, it cannot then be said that it is going to infringe on your dignity, because Section 42(3) of the Constitution is very clear that Parliament, the National Assembly, is obligated to scrutinize the actions of the executive. Therefore, it cannot be that when someone then has to weigh between the so-called infringement on the dignity of the president, it supersedes the constitutional obligation of Parliament of holding him accountable. Look now, there's so much wrongdoing in our country. Now, does it mean that we can't, ministers can't go to portfolio committees? Because in a portfolio committee, those ministers are actually asked questions who could be, someone seem to be embarrassing to them or humiliating to them, but it is part and parcel of the accountability functions of Parliament. Therefore, you can't have ministers subjecting themselves to parliamentary processes in the form of portfolio committees, where they have to answer everything in terms of how they exercise public power. However, when it comes to President Ramaphosa, a different ball game exists, in the sense that he is judged or is treated differently. We must all be equal before the law, Sisbongi. Whether you are Zuma, you are Zungula, or you are Ramaphosa, bonke abantu mabafane phambi komthetho.
Let's see then what the court says. Thank you so much for speaking to us, ATM's parliamentary leader. That's Vuyo Zungula.